due process of law. And that's a quote from the State XRL versus Billings, 55, Minnesota, 466 case, 1893. And these guys were closer to the writing of the Constitution than we are, and they knew what those things meant. They knew what was being done. Due process was intended to preserve established fundamental rights by requiring that they cannot be deprived except by the established modes of law as existing under the common law. The Constitution for the United States was written according to the common law. This guarantee that government shall follow a specified and pre-existing rule of conduct, process, or procedure is in itself a right the citizen held at common law, and was claimed by the colonists in early America. Thus, it is clear that the common law is the foundation of that which is designated as due process of law. Statute law does not trump the common law. That's from 6th ruling case law, constitutional law, section 435. That's a quote. It is clear. The Constitution guarantees these pre-existing rights and procedures in the due process provision. And this quote is from Twining versus New Jersey, 211, United States, U.S., that's the Supreme Court, 78. Quote, what is due process of law may be ascertained by an examination of those settled usages and modes of proceedings existing in the common and statute law of England before the emigration of our ancestors, before they ever came over here. This stuff was existing before we ever came to this country. The expression State versus Doherty, 168504, says this: the expressions due process of law and law of the land have the same meaning. The law intended by the Constitution is the common law that had come down to us from our forefathers as it existed and was understood and administered when that instrument was framed and adopted. In interpreting what due process of law is, it has been held that none of our liberties are to be taken away except in accordance with established principles. That's Eckert versus McGovern, 154 Wisconsin, 142 Northwest 595, 1913. A properly constituted warrant of arrest is a process at common law by which persons could lawfully be deprived of their liberty. The common law on arrest without warrant recognized only certain specific and well-defined cases whereby a citizen could be deprived of his liberty. This cannot be abrogated or changed by the legislature. Otherwise, we're right back where we started before we ever had our liberty. We had right back to the Revolutionary War, which was fighting for these due process requirements. I don't want to go back there. Because I'm afraid I already am. That's what I'm afraid of. Sometimes, if you go into court and you blast them enough and you file enough paperwork, they just don't want to see you coming anymore. And they let you slip through the cracks. But you never really get a response from them.
How can we prove our point that we are under common law and not by which we're operating? Statute law. Statute law is what all your legislators and so forth go by. All your legal schools go by statute law.
Yeah. It's the law of war.
How do you prove that contradiction?
What you're trying to say is how do you show you're under the common law? You're trying to say that you can claim.
Yeah, and not what they teach in all your law schools. How can you do that?
Well,
they say one thing, we say the other. So
yeah, I know.
Is it part of it, though, Bill, that to help answer this question, is it part of it living that way? Like with the way you and John live? You're not necessarily living.
There are certain procedural things that you can do to get yourself out from under statutory or military law, whatever you want to call it.
Denial of corporate resistance.
Yeah, that's part of it too. Being a member of the military. show your status. Status is very important. That'll be something we can talk about a little bit later. That's a very important subject. And that's part of what we deal with. That's part of what this is as far as affidavit of citizenship and domicile. This declares your status, and it breaks ties that would make you something other than that law of citizen.
For instance, they could write a law saying all the criminals are free, all the moral people are in jail, go to jail. Now, how can we say by common law it cannot be in America?
First of all, you have to go in there. They get real nervous when you bring in the truth. See, what they're doing is they're operating in a de facto state of government. They're operating as if they were the lawful government. And of course, because there isn't one that's going to take their place, we're working on that, then they have a duty to maintain peace, maintain order. What we have to do, and that's what this is about, that's why we have to get the word out. That's why people have to become aware. Because we can change that. That's part of what this process is about. But in order to do that, we have to be informed first of what our problem is and what's going on around us and how they're operating. You can't play the game of baseball without knowing the rules. And you just can't do it. You can, but you're going to be looked at as a crazy guy, and they'll kick you off the field.
How far can you trace back common law?
We just traced it back to England before they ever came here. Yeah, you can trace it back to the Magna Carta, 1215. Yeah, it was all the way back there. Now, you're not going to be able to enforce Magna Carta. You can use it, and you can show
But it has
that
a track record of
yeah,
thousands of years.
yeah, hundreds of years, like probably thousands, That's
Not only that, but these judges supposedly have an oath to the Constitution, which puts you right back where you are.
Yeah, see, what you have to do is you have to know these things, and you got to stand toe-to-toe with them. When they start telling you this and this and this, and you ask them, well, you took an oath on the whole Constitution, right? And you got to have the intestinal fortitude, I guess that's all I can say, is to be able to stand toe-to-toe with them and say, no, you guys, you can't do that. This simply isn't right. You cannot statutize away my rights. And you can call them common law rights if you want, but it doesn't make any difference. They're still your rights. And you can't, the legislature, you bring this stuff in, you read this thing in case right to them. Now, they're going to try to get out of it one way or another. There's no question about that. They're going to try to get out because they're operating in a different venue. They're operating differently. They're not there to protect your rights. They're not there to uphold justice. They're there to get you money. That's what they're there for. And or to maintain control over you. And I'm sorry to say that's the way it is, but that is the way it is. If you've been in court any amount of times at all, you're going to find out that's the truth.
I don't suppose you're a big fan of recapturing your straw man, are you?
I'm not going to get into that.
Okay.
You're what?
There's a big argument about that.
Another story for another day.
Yeah. All of this, in some way, can relate to that without bringing that up. But I understand it. Yeah.
You said tonight, and you said many times, if it's a right, it cannot be legislated away.
Right.
Where is that written?
I just read it to you.
I know, but I mean, in that book, that was written by some guy recently, no?
No, I just read it to you with a case down.
Okay, so
I
that's,
just read it to you. It's
Okay, that-
Murray Lisi versus Hoboken and Implement Company, 18 Howard. It's a United States Supreme Court
that is the
decision.
case that statement comes from.
Quote. Let me read this again to you. Quote. This is from